I think just the file is missing, information cannot be furnished, which is not acceptable, we should not accept that. There should be accountability for that, and that is responsible should be public authority. Thank you.
Pending for maybe 3 years, 4 years, 5 years, it did not come up for trial. When it came for trial, the files were missing. The entire documents relating to the case was missing. So the persons who traced all the papers, the accused, documents relating to him, he came before the commission. He said it has taken so many years, nothing has happened. Now the court says papers are missing. What do I do? So the Registrar General was summoned. Because the Registrar General sent the advocate and said, we are doing our best to trace the papers. Okay, the matter stands there. So the same thing, I asked him to file an affidavit. Now, what have you done for the last 3 to 4 years? The most likely what would have happened, the accused would have stolen the records. Okay, now accountability has to be fixed. Do we say that the district sessions judge is accountable and he shall be punished? Just question mark.
It will go missing. Once you know this is an easy route available, file will go missing. So it's an unfortunate thing, people haven't done it so much, but I'm surprised that you're still going to find.
So people have incidentally. MCD, they have what they call their Bazari's license to hawk. 15 or 20,000 files, over 60% are missing. I keep getting them to file FIRs, and because beyond that I don't even know how many years, how many files have gone missing is anybody's guess. And the commissioner has been told, and I don't know what else we could do. I mean,
probably have a room saying missing suggestion that because this is becoming a problem.
We can also think about at the lower end also, at the Panchayat office, the Panchayat Samitis, the block headquarters, where files, the records management system is completely at a total disarray. And to do that, I think under section 41B, this 6 statement of the categories of documents that are held by it or under its control. If each public authority are able to declare what are the documents which are available, which are the missing records at this point of, at a given point of time, and that is updated on a regular basis, at least that will set up a benchmark in the public authorities. They cannot say XYZ file is missing, YZN is available. So that is one, and then secondly, this affidavit. In our case, wherever affidavits have been filed in the open court, we always say that at any point of time, if the citizen can prove that this document is available and the affidavit is a false affidavit, there is a perjury, and under perjury there is 7 years of rigorous imprisonment. That itself, puts a little pressure on the officials, and I have invariably seen. When we say that, they say, no, we'll come back next time, we'll do another search, and this time we'll do a complete, thorough search and give us one more opportunity. Sometimes we have, come to a situation when the file is available, sometimes it's not available. But records management, I think this benchmarking of the records management and recommendations of the records management and following it up with action taken reports on a consistent basis may help this situation.
The document is missing. Then I'm told by the PIO that they have that record. Then second hearing, he brought this board's meeting, minutes of that instructions, board instruction. So I found there a lot of lapses are there. They have not done as per the procedure of the destruction of the record. So I told them this is, I think, a lot of lapses are there, so it is wrong. This is the first thing. Second issue is here the classifications, and they have not done it. And according to me, it should have not gone to the destruction of the record. It's supposed to judicial, I think, decision. It's supposed to keep it for permanent for a long time. Then later on, I had to order an inquiry on this. Then here also again, as he has suggested, the important thing is that section 4B should be implemented. But unfortunately, section 4B, for non-implementation section 4B, so we are not empowered anything. We can't take action on public authority. We have been keep writing to all public authority that section 4B should be complied. But there is no response till now, and especially in Arunachal, my state, section 4B is totally nil. So if this section 4B is properly classified, recorded, maintained, so nowadays it is, you see, age of technology, it's no problem maintaining in this computer, in floppy, CD, whatever may be. So it is very easy. I think this is the only way, the record maintenance, we should give more emphasis. And if, as you said, if record is also missing, at that point of time we can understand, yes, it was missing. And then the destruction of record, that also that procedure are properly followed. That is, I think, very important.
In Karnataka, they will provide information. In case if the record is not found, we will ask them to identify the official who has handled that record last and initiate a disciplinary action against him or inquiry against him and file a police complaint. And major thing is, even for my appeal to this civil this one society is that this 4A and 4B, there is no punishment or there is no imposition of penalty. Because of this only, from past 5 years, this work is not completed. And there must be some penalty against the head of the office. There is a public authority. Otherwise, this work will not be completed even for next 10 years. And number 2 is, you must appeal to the central government and the state governments to see that this Public Record Keeping Act is strictly implemented. If there are no acts, the act should be brought into this one in the states. Number 3 is to earmark funds or to find out some agencies to outsource this work of this cataloging indexing of records. Because no office in the state, whether it is Tahsil office or some other offices, this record keeping is kept in this one. Unless this is seriously dealt with, there is no scope for this RTA Act also. Because if one important record is required, they say that this is not available. If it is a sensitive act, they say that it is not available. Therefore, the thing is, unless these 3 things, that is, number 1 is to make these public authorities to pay the penalty if they fail to comply with this one, they should be made responsible, because especially head of the officers, they appoint one PIO under section 5.1, and because he will be getting the penalty for other provisions, these people are not at all bothered about the implementation of RTA Act, and even this upkeeping or keeping up of this record room update, that is not being done, and they are not giving a serious look also in spite of repeated instructions, in spite of formulation of this one. Government of India is giving funds for various other, this one DOPD is giving. They must earmark some funds. They can assist the state governments also to see that this record keeping is kept, this one, outsourced to some agencies. Let them fix the agencies which are required. And unless this is done, I don't think this 4A and 4B it will not be completed at all. And even if it is completed, that just for namesake they will complete that, and nothing tangible will be done by these public authorities.
You cannot say the non-traceable. I think Mishra will be also be knowing about it. Every public authority has a search system. So when they are telling the file is not traceable, they need to do that provision earlier, beforehand. We tried this in Municipal Corporation of Greater Mumbai, this search options. And some of the documents were available, and after that searching, they need to, by default we told them, now you need reconstruct the documents. That such type of orders needs to come. If the documents are just not traceable, if the FIR is not the base, and reconstruction or redoing of the documents and the search process, which is there in every public authority, at least in Mumbai there are in all the departments are there. So that process if they complete, and that process takes a little time, then they can say non-traceable. Just they cannot say as a non-traceable documents, and that is what we feel so.
See, the records in the Supreme Court never get missing. In the High Court in Delhi, they are never missing. Now, if you have case after case of files missing, it might be a good idea for us to get that information from you, like the Tey Bazari cases, put them all together, go to the High Court and get very strict guidelines for punishment of officials and so on. We'll do that immediately. That is one. Second is, you see, if you've asked the department to catalog and index your files, that itself is information under the Act. So if they don't catalog and index under 4.1A, then you can impose a penalty under 20.
And whom?
On the authority required to furnish
On the PIO
information.
or public authority?
That you decide, but obviously,
You go to section 4 on
yeah, on some, whatever, every public authority shall
Every public authority.
Correct.
Not every PIO.
No,
So
I
on the
say
public
here,
There is no problem here, that's why they issued this circular, but unfortunately,
The law does not give us.
in PIO. But what we had suggested was that let every public authority under directions from the Information Commission set up a PIO responsible for Section 4. Therefore, if the Section 4 is not up to the mark, then you can penalize that PIO. Now, what the CIC has done is recommended it to be transparency officers. I fear that will get stuck. See, you have the authority to direct public authorities to appoint PIOs.
No, agree. Take it a little beyond this. Now, the contempt of court, for example. Now, on any count, every count, the High Court has an authority to take a contempt proceeding. It just happens, at least about 3 to 4 secretaries to government are always in the High Court. Okay. So, jocularly we used to say, let us appoint a secretary contempt. Okay. So, he will be present in the High Court. Now, this will happen if we say, so-and-so PIO will be responsible for this particular section. This unfortunate fellow would be penalized every time and any time.
No, because there is a transference clause here, that's what I'm saying. You transfer.
Additional secretaries, 3 secretaries, and probably 1,000 outfits, BSF, CRPF, their outlets. So, for the 4.1b implementation, if one person or even half a dozen persons are appointed, whom will they pass on the responsibility? I mean, it would be the job which the government should be doing now. You are expecting this information commission to do.
No.
I think government to do.
Maybe I didn't get myself. I'm not saying this. I take your point on board that this particular department needs to have 10 different segments or 10 different. Usually, the joint secretary level, joint secretaries usually in the central ministry head divisions. My own understanding is additional secretaries and secretaries are not really important. It's the joint secretary who head division. So, suppose you say that every division there will be one PI who will be responsible to ensure that the saying that look, within this next month we have to update this particular thing, this is your section, this is your section. So the government is categorized. I also worked in the government, so I know it's categorized like that. There are divisions, there are sections, there this, that, the other. Now if that section officer doesn't, or if that deputy secretary doesn't, the clause comes in there. Information Commission has no role. Information Commission only has a role if a complaint comes to you, saying that look, what was supposed to be done is not done. Then you summon them and say, why was it not done?
No, in a test or in Supreme Court and say, take one case that X ministry has not complied with 4.1b. See how what kind of action the court, what kind of directions the court gives to the government. If the government says that within 1 month or 2 months you comply with it, and then that will be a test case. See, I mean, it is impossible, even if a ministry is asked to appoint a CPIO, as Mr. Sripati very rightly said, you will be continuously only penalizing that man.
That's why I said that.
Please find out